Hi friends, in this video we are going to deal with the important judgment titled as Munni Devi alias NATHI Devi dead through legal representatives and others versus Rajendra alias LALLU LAL dead through legal representatives and others, pronounced on 18th May 2022. In this judgment, the Supreme Court has held that settled exclusive possession of a property of Hindu Undivided Family by a widow would create a presumption that such property was earmarked for realization of her pre-existing right of maintenance. The facts of the case would be that the original plaintiff filed the suit for possession of the suit property along with the mesne profits against the original defendant and against the other defendants who were the tenants in the suit property. Pending suit, original plaintiff and original defendant number 1 expired. Thereafter, the suit was prosecuted by their legal representatives. The suit was decreed by the trial court, against which the first appeal was preferred by the legal representatives of the defendant number 1. Pending the appeal, daughter of the original plaintiff also expired and her legal representatives were substituted in her place. The said first appeal having been allowed by the High Court, the present appeal has been filed by the heirs and legal representatives of the daughter of the original plaintiff with allegation that the High Court committed an error in holding that a limited right in the suit property was created in favor of defendant number 1 and that she had a right of maintenance even under the old Sastric law, which fructified into a full right under section 14(1) of the Hindu Succession Act 1956, whereas the respondents argued that the exclusive possession of a widow of Hindu Undivided Family Property itself would create a presumption that such property was earmarked for realization of her pre-existing right of maintenance, more particularly when the surviving co-partner did not earmark any alternative property for recognizing her pre-existing right of maintenance. The issue raised for consideration is whether defendant number 1, the predecessor of the present respondents, became an absolute owner on coming into force the Act of 1956. The Supreme Court has held that section 14(1) reads that in order to become a full owner and not a limited owner of a property by virtue of section 14(1), a female Hindu before or after the commencement of Act 1956 must be in possession of the property and it must have been acquired by her by inheritance or device or at a partition or in lieu of maintenance or arrears of maintenance or by gift from any person, whether a relative or not, before, at or after her marriage, or by her own skill or exhaustion, or by purchase or by prescription, or in any other manner whatsoever, or any such property must have been held by her as Sridhana immediately before the commencement of the Act. In the instant case, this court is concerned with the claim of defendant number 1 of having become the full owner in respect of the suit property on the ground that she was in settled legal possession of the suit property before and after the commencement of the Act, in lieu of her pre-existing right of maintenance, and such limited ownership right had fructified into full ownership by virtue of section 14(1). Referring to the judgments in V. Tulasama and others versus Sesha Reddy dead, reported in 1977, 3 SSC 99, and Raghubar Singh and others versus Gulab Singh and others, reported in 1998, 6 SSC 314, it has been held that there remains no shadow of doubt that a Hindu woman's right to maintenance was not and is not an empty formality or an illusory claim being considered as a matter of grace and generosity. It is a tangible right against the property which flows from the spiritual relationship between the husband and the wife. The said right was recognized and enjoined by pure Sastric Hindu law, which existed even before the passing of 1937 or the 1946 Acts. Those acts merely gave statutory backing, recognizing the position as was existing under the Sastric Hindu law. where a Hindu widow is in possession of the property of her husband or of the husband's Hindu undivided family, she has a right to be maintained out of the said property. She is entitled to retain the possession of that property in lieu of her right to maintenance. Section 14.1 and the explanation thereto envisages liberal construction in favor of the females with the object of advancing and promoting the socio-economic gains sought to be achieved by the said legislation. As explained in Vitlasama case, the words possessed by used in section 14.1 are of the widest possible amplitude and include the state of owning a property even though the Hindu woman is not in actual or physical possession of the same. Of course, it is equally well settled that the possession of the widow must be under some vestige of a claim, right or title, because the section does not contemplate the possession of any rank trespasser without any right or title. Facts on record would show that different number 1 had long settled possession of the suit property which she acquired in lieu of her pre-existing right to maintenance prior to the commencement of Act 1956, which entitled her to become a full owner of the suit property by virtue of section 14.1. Her exclusive possession of suit property after the death of father-in-law's brother in 1953, that is, prior to coming into force of said act in 1956, was not only not disputed but was admitted by the plaintiff in the plaint itself. Her pre-existing right to maintenance from the estate of the Hindu Undivided Family of her husband was also well established. The submission of the appellants that mere right to maintenance would not ipso facto create any charge on the property, and that for creating legal charge recognizing right of Hindu women to maintenance required execution of a document, device or agreement cannot be countenanced. Her pre-existing right to maintenance coupled with her settled legal possession of the property would be sufficient to create a presumption that she had a vestige of right or claim in the property, though no document was executed or specific charge was created in her favor recognizing her right to maintenance in the property. Therefore, the High Court rightly held that different number 1 had pre-existing right to maintenance in the suit property that ripened into full ownership by virtue of section 14.1.